Hi everyone, I'd like to welcome you to an interactive panel discussion today called Targeting Kleptocrats in Times of Crisis. Has the Ukraine war had any impact on wealth transparency? To introduce the event, the war in Ukraine broke out almost a year from now, and it is one of the key questions in this context is the transparency of assets held by Russian sanctioned oligarchs. And indeed, a task force was established in the US initially called Klepto Capture Task Force to look for those assets. And in Europe, a similar task force was also established. Bringing together these efforts was the launch of the Russian elites, proxies, and oligarchs task force, which includes many countries who have joined the sanctions. However, the issue is not just limited to Russian kleptocrats and oligarchs. It is also that asset secrecy enables kleptocrats and corrupt persons all over the world to hide their assets and indeed wealthy people to abuse tax systems and not pay their taxes. Wealth secrecy involves anything between 7 to 32 trillion in hidden assets, and those assets could be revealed with greater wealth transparency of beneficial ownership registries being open to public and transparent, and indeed other assets being also transparent to the wider public. This event is hosted by the Financial Transparency Coalition, of which I'm the Executive Director, Matti Kähönen, and it is co-hosted by ICRICT, the Independent Commission on the Reform of International Corporate Taxation. And I would next like to ask our panelists to introduce themselves. I will ask them to introduce themselves in the reverse order that they will speak. So I will first ask Bolaji to introduce yourself briefly and then move to the next panelist. Yeah.
Thank you very much, Matti. Good afternoon to everybody, especially to Eva Joly. It's good to see you again, this time virtually. Thank you for inviting me to this conversation, Matti. I hope you can hear me very well.
I can hear you very well, thank you. Yeah.
Very good. I am the chairman of the Independent Corrupt Practices and Other Related Offences Commission in Nigeria. And before then, I was executive secretary of the Presidential Advisory Committee Against Corruption that was set up to advise government on strategies towards dealing with the issue. I'm a member of the working group that prepared the Common African Position on Asset Recovery and also was a member of the UN FACTI panel. Thank you very much.
Thank you. And I'd like to ask if Eva Joly could introduce yourself next. Thanks.
Hello, everybody. I am now working as a lawyer in Paris, and I'm working with the unions, and my specialty is to go after the multinationals to have them pay taxes. And we had a success last year, as you might know. McDonald's were convicted to pay, or had a decision that they should reimburse the state with more than 1 billion euros. Before that, I have been an MP in the European Parliament for 10 years. And I was heading during 5 years the Development Committee. And I was vice chair during 5 years in all the Special Committee on Tax, Fraud and Transparency. Before that, I was a judge in France for a long time. I'm now a commissioner at ICRICT, and I'm a member of the Corruption Hunters Network that I'm running with NORAD in Norway, and where I had the pleasure to meet Bolaji, for instance, in our former meetings.
Thank you, Eva. I'd like to...
Thank you very much. Good afternoon, everybody. My name is Atiya Waris. I'm a professor of fiscal law and policy at the University of Nairobi in Kenya. And I'm also the current UN independent expert on foreign debt and international financial obligations and their implications for economic, social, and cultural rights. Looking forward to an interesting conversation. Thanks.
Thank you, Atia. And finally, Gary, could you introduce yourself, and then we'll kick off to the panel.
Yes, thank you, Maddie, and thanks for inviting me here. My name is Gary Kalman. I am the Executive Director for Transparency International US. As many of you may know, Transparency International is the largest global coalition dedicated to fighting corruption. Here in the US, we focus on the US role in hopefully being a positive force in fighting global corruption, but pushing them to do even better.
Thanks, Gary. Well, kicking off the event, I'd like to first ask Gary the question of what would you say has been achieved since the formation of the Klepto Capture Task Force in March last year, and other initiatives to find the assets of Russian sanctioned oligarchs?
Thanks, Maddie. So as folks may know, the Klepto Capture Task Force was created after the invasion. It is a US-based task force. From then, the Repo Task Force was then created to work with a number of G7 and other countries. It is a little hard. I know people would love for me to say, oh, here's the exact number that they have seized or frozen or what have you. Unfortunately, we don't know that. Last June, there were some press statements about what they've seized, and so we know about a $300 million yacht in Fiji and a $90 million yacht in Spain, the $60 million Gulfstream jet, and the $350 million Boeing aircraft. We could go on. So there's a bunch of sort of as they take cases or as they move, they put out press releases, but it's not clear that we know exactly a number. It's clearly in the hundreds of millions, and by now it's likely over $1 billion. In terms of the Repo Task Force, they also put out something last summer saying that they have frozen about $30 billion worth of assets and $300 billion, and immobilized, what they say, $300 billion of assets from the Russian central bank. So there's been, suffice it to say, even without knowing the specific numbers, there's been a lot of assets frozen. And I do want to make sure people are clear. Frozen is not the same as seized, right? So when countries issue sanctions, they can fairly quickly freeze assets, make sure that the folks that are are the original owners of those assets can't use them, don't have access to them, don't benefit from them. But seizing them is a much more difficult process. You have to go through law enforcement and criminal proceedings, which in rule of law countries, while frustrating in its time, is a positive aspect of our democracies. The interesting thing about the Klepto Capture Task Force is, and I think something that's critically important for us to understand coming out of this experience, is that it involves 3 people in the US government and a lot of negotiations and discussions and steering committees and task forces and other sort of conversations with other agencies at both the state and federal level. But it doesn't involve it has not involved the creation of any new laws, new authorities, new rules, and even any significant new resources. And the reason I say that's important is because the speed with which information is now being shared across borders and working with its partners in the Repo Task Force is due in large part, when you talk to people in and around law enforcement, to political will. It is just that it is being prioritized, that we are beginning to realize that these hidden assets have national security implications, that it is far more money than people may have realized 10, 15 years ago. And it is critically important that we begin to prioritize these kinds of investigations. And the only way we're going to do that is by speeding up the information sharing process. So the reason I say that's important is, coming out of this, the big question is going to be, how do we expand the information sharing so that we can continue these expedited investigations? How do we expand it beyond Russia? Because as the speakers that will follow me will no doubt be able to explain in further detail, but this isn't just about Russian oligarchs. We know that there's hidden money from countries all over the world. The countries in the repo task force are the ones that need to take a look internally and take responsibility, because the vast majority of the assets, I don't remember the exact number, but I remember thinking it was somewhere around 70 to 80% of estimated hidden assets are in countries of jurisdiction that are in the repo task force. And so the US,
Yeah.
EU, right, are responsible and need to take a look at our own laws in order to make sure that we're not helping to continue to facilitate. So let me stop there, but that's a few pieces that I think are important.
Just a quick follow-up on the US laws. I mean, US is now advancing some financial transparency legislation and enabler legislation. Can you just very briefly say which bills are those and what hopes you have for their success?
Yeah, no, the exciting news here is exactly that. After years and years, in fact, decades of inaction, where we hadn't updated our anti-money laundering laws or given new authorities to the Treasury Department or the Justice Department, finally, we are beginning to see a breakthrough. And so just a couple of years ago, the US Congress passed and the president signed the Corporate Transparency Act, which for the first time will require companies to declare their beneficial owners, that is the real people who own and control companies. So you will no longer be able to create an anonymous company in the United States that you can use for nefarious purposes. It's not public, which we can talk about later, and that's a shortcoming of the law. We weren't able to get that, but at least law enforcement and financial institutions will have access to it, and the information will be shared internationally with our partners. So it is a big step forward, and we're waiting for regulations to be finalized for that law to go into effect. The target date for that is next year. The other law that is going into that we haven't passed yet, but we made some great progress in the last Congress and hoping to continue in this one, is called the Enablers Act. And while the US does require banks and certain financial institutions to do due diligence on their customers and know whether or not they're managing and moving dirty money, the lawyers, the accountants, the corporate formation agents, the trust formation agents, none of the real estate agents, none of those have those responsibilities. And so we want to move a bill here that would allow Treasury to begin on rulemakings for those that are not covered under the current law. The last thing I will say is there are two sectors in the US economy that are covered by the current law, but the government has never moved forward in creating rules or standards for those sectors. What happened was after 9/11, there was a law that was passed to update our anti-money laundering laws, as well as other things, that included real estate agents and investment advisors. And shortly after that bill was passed, the real estate sector and the private investment sector got themselves temporary exemptions. And we say temporary with a smile on our face because we're now in the 23rd year or 21st year of a temporary exemption, which is crazy. And so we finally have a Treasury Department that is moving forward. They have started a rule to rein in the real estate sector, and they've indicated an interest in reining in the private investment sector. And let me just say one last thing before I stop. These are huge markets in the United States, and people may not appreciate it, but the real estate sector in the United States is $60 trillion. The private investment sector alone is $11 trillion. If the private investment sector of the United States were its own country, it'd be the third largest economy in the world. So there's a lot of space to hide dirty money. These people have no responsibilities to actually know their customers. We think it's time for them, long overdue for them for that to change. And we now have a Treasury Department that's finally willing to take some steps. So we're going to be pushing them to complete those rules.
Thanks, Gary. That's great to hear where some of the challenges and some of the advances may lie. I'm turning next to Attia and ask, basically, what would you say are the human rights concerns related to asset recovery? And what principles and guidelines would you consider are important in that matter?
Thanks, Matti. I wanted to add that I also think the entire luxury market in many parts of the world are also enablers. Whether it's art or it is buying of designer items, I think all of these can be seen as enablers when it comes to how money is utilized. But yes, fascinating conversation. I'm really enjoying this. From my perspective, the Human Rights Council requested that I draft guidelines on the unconditional repatriation of state assets 2 years ago. I completed it. It is going to be presented officially to the Human Rights Council in March, which is next month, but the report is already online. And the reason that I refer to it is it's the basis on which I will be speaking going forward. One of the first things that I noticed when it comes to the repatriation of state assets is that there's a lot of conversation around its repatriation, but there isn't a conversation around the ethical repatriation and the reasons behind ethical repatriation. And so I would take the step forward and talk about a human rights approach being this sort of ethical framework by which state assets should not only be held, but should actually be returned back to where they come from. Two examples come to mind. One of them is the freezing of bank reserves that has been taking place across the world through sanctions, sometimes legitimate and illegitimate. And while we talk about private sector investments as well, the freezing of public assets is becoming quite crucial right now. There are countries that are unable, for example, to pay membership dues to the United Nations because of the freezing of their assets. And so this is a very complex space, and it's getting more complicated. So it's not just about private sector players. I also see it as public sector players. And so what I looked at was what would be the guidelines that would be utilized in the repatriation of these state assets, for example, and what would be the human rights concerns around it. And from a human rights perspective, there are 4 key areas to look at. The first is the issue of international cooperation and assistance. If we have a cross-border activity taking place, then there must be equal international cooperation and assistance. And the problem that we are seeing, of course, being highlighted by the current situation, is that it is being used selectively as a power play. And the moment we leave it in the space of it being a power play, we lose the ability of raising living standards. We lose the ability of actually making sure that the world is moving forward at an equal level. So that was the first part, which was international cooperation and assistance. The second is about equity and non-discrimination, which I've already alluded to. But it is not just about non-discrimination between states, but also within states. It's about the private sector players. So even as we call into account the real estate players, are we also looking at other players that work with cash payments? We have a new space now, which is digital currency. A bigger concern is how are we going to monitor purchase and sale of digital currency in this conversation, where assets are being stored and how they're being stored. The third issue, which I think is quite critical from a human rights perspective, is participation, ensuring that there is conversation happening and that decisions are not being made unilaterally and unconditionally. A lot of the sanctions that I have seen are actually done unilaterally, and they are crippling countries right now. Last year, for example, myself and several experts wrote to the US government concerning the freezing of Afghanistan's resources, because in the COVID era, people are dying because these assets are not being released. And so there is private assets and again, public assets that come into play. And the last principle, which I think is very key, is access to information. It is very important that we have access to information. Not only people on the ground should know where assets are and how they're being dealt with, and that we should be able to have transparency to make sure that we know for whom they are being utilized, from where they are being taken, how they are being treated. But it's also fair for the person who's giving the resource to the state. I think for all stakeholders in that conversation of financing a state and financing its development or maintaining its development, access to information remains quite key from a human rights perspective and stuff.
Thank you, Atiya. Maybe a follow-up question then on transparency. What obligations would states have, in your view, on beneficial ownership transparency and also wider asset transparency, like you mentioned, those art pieces and others?
Thank you, Matti. So beneficial ownership is something I spoke about in my General Assembly report last year when I talked about the creation of a global financial architecture. It's something I think is quite critical. Interestingly, my report came almost simultaneously with a report from the Secretary General of the UN stating that it was very important that transparency remains a key cornerstone in all of these discussions. But beneficial ownership and the registry specifically, if we are to look at it from a human rights perspective, have several implications. The first is access to information, which I've already covered in quite a bit of depth. But the second thing is it's about the fairness and equity of who pays how much they are paying. And so it's not just a human rights principle from the perspective of the state collecting resources fairly from the residents within its states, but it's also about fairness and equity in the system and then redistributing that same asset. And so beneficial ownership, if we look at it, it balances off by making sure that we're collecting the right amount of taxes and then we are redistributing fairly. And that also protects other taxpayers from not having to pay additional taxes because another taxpayer is not paying what they're supposed to pay. What it does bump heads with, from a human rights perspective, actually, is with the right to privacy. But this is a peculiarly European problem rather than a global issue. It's only within the EU that you have the rule that corporations have rights to privacy. From a human rights perspective, it's a debate that has been taken forward quite a bit. But as far as the rest of the world is concerned, that particular right has not developed in that way. And so multinational corporations don't have the same kind of right to privacy protections in other parts of the world. However, the problem does arise when you have a multinational corporation that's headquartered in Europe now dealing with the countries across the world, because what they do is they then come in with the lens of human rights and the right to privacy in their dealings in developing countries. And then you see this constant back and forth in their negotiations because they feel that they are also entitled to a certain type of protection. But this right to privacy interpretation within Europe is not something that the Universal Declaration ever considered, or in fact the international covenants. So it's an interesting dilemma because so many multinational corporations are housed in Europe. I'll stop there, but looking forward to the conversation. Thanks, Matti.
Thank you, Atiya. I'd just like to remind all of the listeners that there's a question and answer button where you can post questions to the speakers. We'll get to the questions after the panel has had the initial reactions. And also interpretation is available in Spanish, just to remind you of that. So next, Eva Joly, picking up from where Atiya left us, indeed, the EU has been for many years at the forefront of transparency initiatives, but recently in December, the EU Court of Justice delivered quite a big blow to beneficial ownership transparency, invalidating the provisions of the Anti-Money Laundering Directive, whereby information on the beneficial owners and other legal entities in the EU was accessible to the public before, but now that's been shut down. So why is financial transparency, in your view, important in the fight of illicit financial flows?
Yes, this is really a very sad thing. And in my opinion, the court did a very big error. They put a setback of some 10 years to our fight against money laundering in some hours. And there has been an inquiry then since then by journalists who looked into who was the person that did plead this case, that pretended that his privacy was violated by the fact that in Luxembourg, anybody could go and have a look at the register. He pretended that he could be hijacked if they knew how rich he was. This man was called Patrick Hansen. And he was seen as a successful businessman with a company lending threats. But after this inquiry by the journalists, they found that he had more than 100 companies. Many of them were with Russian stakeholders and shareholders and people very close to Putin. And this had been going on for years. So what this means is that this argument of Mr. Hansen's right to privacy, the court did give privacy to the oligarch and to Putin's friends. And I doubt that this was what they wanted to do. So what I'm thinking is that what the court has done in one judgment, they can undo with another. And we should not hesitate to take a case to court and to show them how much they were wrong and what the consequences are of their ruling. I think this is really terrible, and I'm very grateful to this organization. It is the Organized Crime and Corruption Reparation Project who did this. And so we see, and that in a way, it is terrible how this court, composed of judges from all the European states, how they are living in their own building, how they are not informed, and what they are doing, not really probably understanding what it means. So I think this is a monstrous error. You seldom see that kind of error. But we must continue to fight and find other ways to get rid of this limitation.
Thank you, Eva. Indeed, many of the beneficial ownership registries have already shut down since that ruling. But I agree with you that what has been done by the court can be undone.
Exactly.
You also championed the Global Asset Registry as one solution to the various obstacles about who owns both companies and other assets, because those can indeed go beyond beneficial ownership registries. Can you tell us a bit about this proposal and how it would help to find assets of oligarchs and others?
What we have seen today in the US, in Europe, is that it is terribly difficult to go after the oligarchs' assets. We know the figures. They are holding a huge part of the Russian private wealth, and estimates are that 3/4 of this fortune is held in tax havens, and it is set up with the normal, very complicated schemas, which shows that making seizure and confiscation is nearly impossible. You gave some figures. Europe has confiscated up till January this year more than $1 trillion, excuse me. But that is because we have the assets of the Central Bank of Russia. So it's not really the oligarch. Nice or important to note that in the seizure, Greece and Malta have done nothing. They are only about $100,000 in seizure. Many other countries have seizure in billions, but these two countries don't. And we know that Malta is a favorite place for Russian oligarchs. So this is really a mess. So in order to be able to trace assets, and not only Russian assets, we need this global asset register. That means that around the beneficial owner, you should link all kinds of assets that he has with the place these assets are. Most countries has already registers with houses, planes, yachts, and other things. So these registers should be linked to the real owner, and they should be interconnected. This is to start with in every country. And this is already a tremendous work because, as I told you, Norway don't even have records of who are the owners of their properties. So a lot of work to do here. And the idea is that once the member state has their national register around the beneficial owner with all his belongings, we should interlink these registers and then have a European global asset register. And we could think, for instance, that it should not be possible to sell your car, your yacht, or even your Philips Patek if you don't show that it is registered in this global asset register. So this is I think, a huge idea. And we see here that this would make the seizure of the oligarchs' properties possible, because we have seen today that even if everybody knows that the yacht of Putin himself is there, it is impossible to prove it, and then you can seizure it for some weeks maybe, but it's expensive to maintain them, and you have nobody to pay invoice. It don't end up with confiscation. So here we really see all the negative parts of trusts, of tax havens, of these secrecy jurisdictions. So very important to continue the work that we have started in ICRICT on the global asset register. And we can dream that if we have it in the EU, the US could have it maybe, and then we would have most of the world, and later on in the other continents.
Thank you, Eva. I certainly very much look forward to having the Global Asset Registry. Where I live, there are many mansions and parts of the country in the UK where I live that nobody knows who owns them. They're hidden behind trusts and hidden behind offshore vehicles, just like it seems in Norway. Yeah.
Yes, and I remember Cameron in 2015, he promised to make this register, and he promised that trust should not be anonymous anymore. But we are still waiting. Yes,
indeed. We were hoping that the UK Economic Crimes Bill would provide that registry, but still there's some reporting gaps on that particular registry of foreign owners of UK property. I would like to next turn to Professor Bolaji Owasanoye and ask you really about the experience of Nigeria, which has been in many ways at the forefront of fighting illicit financial flows, both at the UN and at the national level. And what is your experience in terms of investigating corruption, and what types of obstacles have you faced in Nigeria in obtaining also information from other jurisdictions?
Thank you very much. If it is any comfort, I think that the similarities from what I've heard this afternoon, they resonate also in Nigeria, maybe at a local level. For example, the big challenge is never with investigation of small fries or low citizens or poor people or ordinary people. It's always when you investigate the high-profile politically exposed persons, those who are highly politically connected, and all that. And in Nigeria, the challenges revolve around the abuse of the concept of federalism, for example, by subnationals, where very corrupt state governors, for example, will obtain court orders from their own state courts, preventing federal anti-corruption agencies from investigating, arresting, or prosecuting them. In some cases, they will set up their own anti-corruption agencies. Of course, there's no intention that they be effective. It is just designed as a subterfuge. And they will put laws, sections in those laws saying that those agencies are to take over all cases that involve the state for investigation. Of course, this is a running battle, and we are challenging some of these laws in court. But this is one example of the full pushback to prevent investigation. Then there's also the abuse of the concept of separation of powers by the arms of government, especially with fiscal corruption, that is the abuse of budgetary allocation. So you find a pushback from the legislature or the parliament, from the agencies, anti-corruption agencies, who are then regarded as agents of the executive. You prevent them from doing their job to investigate corruption involving how, for example, the budget has been used, abuse of power, and what have you. And the same thing with the judiciary, trying to push back. I mean, it's ridiculous because neither the legislature nor the judiciary has its own police force. It doesn't have its own investigating arm. But yet, when corruption happens within those arms of government and anti-corruption agencies choose to investigate, there's this pushback abusing the constitutional concept of the separation of powers. And then, of course, this is woven around either ethnic, religious, or political biases or other fault lines. So the challenge is very real. Then at the international level, especially with regards to information sharing, obtaining information from foreign jurisdiction has been a very sticky point, especially where there is no mutual legal assistance regime about how evidence should be collected and how it should be shared. Even where there is, the delays are legendary. Sometimes some countries don't even respond to a request. Many countries have refused to publish, how do you want us to make a request of you? If Nigeria wants information from France, how do you want it presented? What format do you want? Are there timelines? Who is the contact person? So many countries simply refuse to cooperate in this regard. And obviously, it's surprising to me because at international meetings, we are all jojoing about the importance of fighting corruption. But when it comes to the real micro level, where we then have to investigate specific cases, all manner of obstacles are put in your pathway. What anti-corruption agencies and law enforcement have tried to do informally, including my organization, is to try and set up regional and informal information sharing platforms through which you can, if there's an ongoing investigation about a big shot, we can share information confidentially. But there are still concerns even around this, and these concerns revolve around data protection and privacy laws. Just exactly what the European Court of Justice recently sealed with a big stamp, which means the little we used to get before, we probably will get nothing now. There are those platforms at which you can confidentially share information, because as we know, stolen capital is very fungible and very timid. Once an investigation starts, it moves. It changes its color. It changes its image, and it's forever a moving target. So one of the things that we really need to emphasize is the importance of information sharing. But this is the very one thing that the whole world is struggling with. And then there's, of course, this level of mutual suspicion about the global north not trusting sensitive information in the hands of the global south. And yet, these assets have been stolen from here. They have been moved to havens in the global north, controlled most likely by financial institutions in the global north. You want information, you can get it. So the last leg of that is that sometimes I wonder that the reluctance is based on the fact that, well, everybody wants to be seen as being the one who busted a big organized crime or achieved a milestone in an investigation. And around that, according to UNCAC principles, is the ability to earn some administrative fees for the effort made. Now, those fees are not controlled or capped in any manner. So 1 billion stolen from Nigeria, if it finds its way to any country, by the time you are able to negotiate a return, we don't know how many years after, maybe you'll be getting 600 million or slightly more, because the law says, oh, you can charge some administration. So sometimes I get the feeling that behind all of this frustration about not wanting to share information and not wanting the country to make progress is because somebody wants to be able to share part of the money at the end of the day. This is an uncomfortable thing for some countries to have to confront, but this is just the reality. Thank you.
Thank you, Bolaji. Indeed, the legal fees, if we look at cases of the Abacha 123 or the current case in Kenya, are actually quite large as a share of the potential assets that could be returned. So there's a clear issue in there. Just like to ask maybe a next question about that you've developed a common African position on asset recovery. How do you think that could improve asset recovery efforts, and also would create a beneficial ownership transparency across Africa and also in countries where IFFs end up help in those efforts?
Yeah, the common African position on asset recovery is a direct fallout and a product from the report of the Mbeki panel on illicit financial flows, which is globally acclaimed. One of the measures that is anticipated is how to strengthen African countries to know what to do. So the Common African Position on Asset Recovery, CAPA for short, is both a policy, an advocacy, and a political document to guide countries to know what to do. And it hinges on 4 pillars, the first of which is detection and identification of assets. Many countries don't even know what to look for. If you look at illicit financial flows that arise from commercial transactions, a lot of those things are hinged on tax transfer pricing. And with big multinational corporations, they are expert in hiding the figures and diluting it, and of course, shifting profit. So you must know what to look out for. So that's the first thing. Of course, that's not the only source of this sort of corruption. You also have the criminal looting, and you have the corrupt looting, and then you have the commercial. And then, of course, the second major pillar is around return or recovery and repatriation of those assets. Now, of course, as we know, many recovery cases drag on the average 5 years. That's a long time. And like Atia said, while you are negotiating, the people who need the public funds are suffering. The countries, the victim countries, are unable to meet development goals and continue to depend on development assistance, which is inadequate, or borrowing, which further compounds their problem. And going by the time value of money, by the time you succeed, if at all, and from reports published by UN STAR Initiative, we know that the level of success is abysmally poor and low. It appears that the spirit of UNCAC is not moving at all. So if you succeed, the time value of money, the value is eroded. So one of the things that CAPA suggests, for example, is to invest funds that are in dispute in development banks. If $1 billion has been stolen from Nigeria and we're negotiating how to return it, even if it is being contested by the suspect, the defendant, put it in an investment account. By the time we conclude the negotiation, the money has added value. The banks who usually facilitate and are enablers, and this is globally known, they benefit from both sides. They enable the money to be stolen in the first place. They pretend that they have not invested the money while the dispute is going on. And when the matter is eventually resolved, they return the face value or less than it. So the money is at that time worth half of what was originally stolen. So CAPA recommends a framework which was also adopted by the UN FACTI panel. Put the money in an escrow account. If you win, you get the money with value addition. If the victim state wins, they get the money with value addition. If the requested state holding the funds wants to charge administrative fees, they can still take it from the accretion to the original principal. And so the victim state does not lose on both sides. So that's one of the major principles. The CAPA itself is designed to build the capacity of African countries and show what is possible and guide as to how to go about it. And it includes negotiation for the return of artifacts and heritage objects, which are linked to the very identity of the people. And Nigeria has succeeded greatly in having a number of artifacts returned and many more in the pipeline. Now, with regard to its link to beneficial ownership, of course, this goes without saying that beneficial ownership frameworks and standards will help. And I totally agree with the position taken by Eva Joly that Nigeria has recently changed the laws in 2020, to be precise, for beneficial ownership disclosure. This is now statutory and is mandatory. The big challenge is with updating the records with regard to the myriads of companies that had been incorporated before the new regime came, and how you will get that information to update it. So right now, we do not allow the incorporation of companies with nominees or as trusts, and we do not know who is behind them. There must be flesh and blood behind every artificial entity, every artificial person that is incorporated and is recognized and allowed to do business. Hopefully, we're going to be able to introduce other standards. Our extractive transparency initiative agency called NEITI is very much on top of making sure that there are other standards that are enforced, not just around beneficial ownership, but if you're a company wanting to do business in the extractives and you are incorporated in a tax haven, that should be a red flag, because we should ask you exactly what are you doing there, and you want to do business and you want to do it behind a screen. We don't want that. If you are incorporated in a jurisdiction where all the records can be made plain, that makes it easy for us that you have nothing to hide. So these are some of the standards that hopefully will be attained. Thank you very much.
Thank you, Professor Bolaji. I think that gives us a very good introduction to some of the challenges and obstacles faced by those investigating money laundering and trying to work on asset recovery. I'll now open questions and answers first to Professor Bolaji, so that he has to leave the panel in 10 minutes. So would anyone first from the panel itself like to just ask a follow-up question to, you can raise your hand, or from the audience? Yeah, Atia, go ahead, please.
Sorry, I just want to have the conversation. This is something I discovered which fascinated me when I was drafting the guidelines, was the fact that, well, Professor talks about 5 years, but on average, African countries and many developing countries take even 10 years to get the money back. And so what became very important from a human rights and a development perspective when I was developing the guidelines was that they only get back the principal amount. So there is not only no interest attached to it, there is no earnings attached to it, there is also no recognition of inflation and the change in purchasing power parity on what a country could have done with the money in that period. But also there isn't a recognition of what the loss in development itself would have as an impact in a lot of the countries across the world. And thank you, Professor, because you reaffirmed what my guidelines are saying, and I hope you'll have a look at them as well. I think they will be useful for many countries.
I'll pick a question from the audience that's addressed to all panelists. So the question says, were the assets of US or NATO countries frozen in the aftermath of wars in Yugoslavia, Iraq, Afghanistan, Libya, Somalia, and others, or are assets of Saudi Arabia frozen in the context of illegal wars in Yemen? So it's a question about double standards in terms of freezing assets and international sanctions. Would you have a perspective on that question before we leave?
Let me just jump in and say something briefly about this. I think one of the things that has intrigued those of us from the global south who are observing is to see that where there's a will, there's a way. In the advent of the war in Ukraine, we've seen the speed with which the global north organized itself to freeze assets. And it means that where there's a will, we can actually work together to fight corruption. But if the requests had come, and that's what the question really underscores, that this element of double standards all the time, it keeps rearing its head, and it sends a mixed message about commitment, the global commitment to deal with global issues and matters of global concern. At least we know now that this is possible. But in the past, when you make a request, you are confronted with all manner of quote and unquote supposedly rights issues, private rights issues as to why it cannot be done or it cannot be rushed, and why you have myriads and series of diplomatic conversations to decide whether or not you want to go forward or not. But here we have a situation that threatens the whole world, even though it's within Europe there, but it's a global threat. And the response has been very good. So I think that it's an example of where there's a will, there's a way. Thank you.
Thank you. There's a second question in the Q&A box to Professor Bolaji. Do Global South countries have a technical political space where they share best practices for asset recovery and for demanding as a bloc, as a group of countries, more cooperation from the US and European countries? Does such a space exist?
Oh, yes. This sort of opportunity is taken to, for example, the Conference of State Parties. Just late last year, Nigeria, supported by the group of 77 African countries and all that, pushed forward a resolution to place the international tax regime of corporations within the taxation regime of corporations within the international UN framework. We know it's a long road yet to travel, but it's a major success. At the UN Conference of State Parties in Egypt 2 years ago, I think it was, for the very first time, a resolution was adopted on beneficial ownership transparency. So African countries get these opportunities to take the issues to the global space with the support of other countries to have some of the issues discussed and a pathway charted for cooperation.
And maybe just then concluding the questions to you, I would say that you were a member of the FACTI panel as well. And as part of that panel, you made a number of recommendations to reforming some of the international architecture on asset recovery and on international money laundering. So I guess from an African perspective as well, how would you see that some of its recommendations at the global level, in addition to Mbeki panel's recommendations, could help to uncover assets of all oligarchs? And how? Yeah.
Well, first of all, to say that the FACTI panel was a UN General Assembly and President of ECOSOC initiative. So in that respect, it's a global with representation from all parts of the world. But they found some of the Mbeki panel recommendations useful and far-sighted and foresighted and adopted them. And I've given one example. So that's very gratifying. The second thing, of course, is that it shows also that the validity and the importance and the currency of the recommendation of the Mbeki panel report, because the issues raised in the Mbeki panel report remain very much alive, especially for the African countries, about tracking illicit financial flows, being able to stop it, and then, of course, to recover it. These are contemporary issues, and that report itself is almost 10 years old, if not slightly, about 10 years old. So we find that it remains very relevant in its recommendations. We're discussing the issue of illicit financial flows, money laundering. These were issues covered broadly in that report about how it happens. And if you don't know how it happens, you would not know how to stop it. because it might pass right in front of you and you will not recognize that this is illicit financial flows. So that Africa could stop being a net creditor to the world, because right now that is what it is, that Africa is transferring a huge part of our assets to the global north.
Thank you, Professor. I understand that our hour has come to the end with you, so thank you very much for joining us today. And I will now also turn to some of the other panelists.
Bye-bye to everybody.
Thank you so much, Bolaji, and have a great time in Bamako where you are. Thank you so much for joining us, taking time. So I'll just remind all the audience that you have a question and answer section in the Zoom call, in the Zoom webinar. So please use that if you want to ask a question. So there's a question here to Gary. And it's a question about the distinction of assets. And so why are the assets of the Russian Federation frozen by the West, which is deemed to many be illegal under international law, even figuring in this discussion? Were those assets not a result of a bona fide exports by Russian Federation over the past decades or so? So it's about the Russian state bank assets versus oligarch assets.
So let me start by saying I'm not a particular sanctions expert, but I will say that the use of sanctions means, as I think I said before, and it's an important distinction, is that you are freezing assets because you believe that there's enough evidence, at least, that the assets are connected to illicit activity or supporting illicit activity. And so, there are a lot of questions about who we sanctioned and why we sanctioned, who we didn't sanction. For example, the EU, I believe, has sanctioned Mr. Abramovich. We in the US have not sanctioned him for whatever set of reasons under our laws and requirements. I do want to be clear, though, that that is different than seizing the assets. And so that does require a full court trial, and those who have had their assets seized will have an opportunity to go to court and say that this is not part of the Russian invasion, or that it should not be confiscated, and they'll have an opportunity to put that in court. So I think that would be the distinction here, where the rule of law will protect them at the ultimate disposition of their assets.
Yeah, thanks, Gary. Does anyone else want to jump in on the state assets versus oligarch assets?
¿Alguien más quiere hablar acerca de los bienes del Estado y de este tema? O de los estados de los oligarcas. Quiero decir que tienen distintas protecciones a nivel de las leyes internacionales y creo que también a nivel individual. También ¿dónde es que es posible que estos oligarcas lleven sus bienes de los oligarcas rusos? Puede ser.
I think part of the problem that we have, and this is, we've gotten a lot of questions from reporters, and I'm sure all the panelists have, if we're seizing all the oligarch assets, how are they still living? Like, they still are traveling around the world. They're still, living in nice houses, et cetera, et cetera. And one of the more ironic questions I got was from a reporter who worked for Hedge Fund Magazine. It was a publication that was specifically for the hedge fund industry. And I said, well, you should be familiar with this because they're hedging their bets. Some of the money is in public, right? There is some public investment that a lot of these oligarchs had made prior to being sanctioned, but under concern that something could go wrong or they would be sanctioned in the future if Mr. Putin did something. I don't know that they envisioned invading Ukraine, but whatever might happen. And so they put their money into these secretive entities. And so moving them from jurisdiction to jurisdiction, from secrecy jurisdiction to secrecy jurisdiction, might provide them an additional layer of secrecy and protection for them, But it's hard for us to sort of quantify or know exactly where the assets are moving. The other thing I do want to, if I may, just pick up on one issue that was raised earlier about the repatriation issue that the professor raised. And that is that in the US, if you ask about asset recovery and return, the US, while taking great strides in a number of areas to try and uncover secret assets, has not done a great job and has actually not been helpful in the global, on the international level, in trying to push for greater asset return. And when you talk to them, they talk about various structural difficulties in sharing information and moving on cases. And one of the things we hear a lot is that through the MLAT process or through other mechanisms for trying to share information, the things that they get, the forms and the requests, are not in compliance with US law. And so therefore they can't actually process them. To which I said, and I asked, well, okay, that seems like a simple training problem. Or you can have forms that have, if there's certain specific things you need, you could have a drop-down menu. This technology has existed in the world for, 30 years, right? And they can just choose, and therefore you eliminate people not quite fully understanding the US system, which is completely understandable. And the response is sort of blank stares. And so I do believe that we're not going to be able to solve all the problems, but there are some small steps we could take that would have an enormous impact. And we need to start pushing the US government to own up to its own shortcomings in how it's requesting the information so that they could respond more quickly. This is not, it is not entirely an unsolvable problem. So just to add that to the mix.
Thanks, Gary. Maybe I'll make a question. Professor Bolaji mentioned that actually many African countries have quite advanced beneficial ownership registries. And I wonder, and also actually Latin American countries have lower thresholds on registering beneficial owners compared to the current European and UK and proposed US beneficial ownership registry that's due to be effective as of 24. In Europe and the US, it tends to be 25% is the threshold for registering beneficial owners, but I've seen that the African and Latin American registries have a much lower threshold. Atia, you sound like you could respond on that. What are your reflections on lowering the threshold and making assets more transparent that way?
No, I'm nodding for a couple of reasons. One is that when I hear Gary's argument, which is a fair argument, I always think about as lawyers, we sometimes are supposed to look at the form over the substance, or should we look at the substance over the form? And I think from a human rights approach, just out of fairness and justice in this entire space, shouldn't we be looking more at the content rather than tripping over ourselves with the forms? And while it may be also easy with the drop down, there's also issues of language. Not everybody's first language is English or French or Spanish. And unfortunately, when you have documentation in those parts of the world, and frankly, when the assets are in those parts of the world where that is the language that is used, I mean, I don't know how you're going to get somebody whose national language is Swahili, for example, to understand technical language on the other side. And I think there's an unkindness in this system, which I think human rights could actually give a lot of positive shadowing or layering to it. But on the issue of beneficial ownership, the fixing of the percentage is based on an understanding that it is a large amount. But depending on the size of the company, even 2% can be a really big holding. And living standards are so diverse that I think sometimes we just simply should show full transparency. I to date, from a human rights perspective, but also from a tax perspective, I still don't understand why we cannot just disclose what we own so that we can pay our fair amount of taxes and then actually have development happening across the world. So yeah, that's me being a little provocative.
Can
Yeah, go ahead.
Thing is to say, first of all, I agree. I'm not actually I want to be very clear. I am not defending what the US is doing. And if my solutions are not whole, there's broader and better solutions, I am open to them. I think it is a US deficiency that we are not actually doing a better job. If we see illicit activity in the US, right, in communities here in the US, we will do whatever it takes for those law enforcement agencies in a city with the state to the federal government to coordinate and organize and move to find the solution. And yet, when it's our overseas either allies or, we see harms happening around the world in countries that are not the US, we tend to then fall on legalistic arguments. So I want to be very clear that, yes, I wholeheartedly agree. And what I'm saying is the US should, in fact, figure out ways to make these, don't let the forms be the obstacle in going after what is truly horrific behavior that's resulting from stolen assets. So I'll stop there.
Maybe a question to Eva on the European registries. The 25% threshold has been somewhat controversial in allowing basically setting up 5 owners of a company that own 20% and you don't need to register them. Do these obstacles, could they be overcome? And what would you say?
I think we can find ways to deal with this. If we have a global asset register, we will find ways. I wanted to share with you another preoccupation, which is that the service providers, some service providers do offer even the service of fronting the beneficial ownership. And I think this should be forbidden. I mean, this should really be sanctioned, because this is a huge danger. If at the end you only have a representation even for the beneficial owner, then we have made no progress. So I think that is maybe one of the main points to deal with. And also we observe that Russian money are leaving sanctioned countries. They are leaving for other parts of the world. So we must also be quick before they are successful in moving it to China, for instance.
Thank you, Eva. I had just maybe another quick follow-up question. I mean, how the recovery of assets seems to take such a long time, and you worked as a judge in Paris on recovering and looking at anti-corruption cases. Do you have, from your experience, some ways in which things could be made a bit quicker and a bit easier for law enforcement agents?
It is really terrible. When I started working, there were not such a thing as returning assets. The assets stood in the countries where they were found. And it was with the Abusha case that Switzerland started returning assets on a voluntary basis. And I was one of the negotiators in the UNCAC for Norway. And Norway, we requested this point that the assets should be returned. But this met a huge resistance. We had the support of African countries, for instance, but we didn't have the support of most European countries. And so I think there has been a lot of resistance of this idea. And still today, we are not successful. And it is because also of the proof. You need to prove that this money did really belong to Nigeria or to another. And this is very often very complicated and very long. So I think still a lot of money is returned on a voluntary basis because you don't have the final legal decision. So this is still an open subject, And there has been many initiatives in order to improve it, the World Bank, the STAR initiative, and it's very sad to see that 20 years after, it was in 2003, I think we signed. 20 years after, this question is not really settled, and this is also because in most countries the legal systems are slow and under-equipped and so on. So we are all suffering from that too.
Yes, thank you, Eva, for that remark.
I think one of the recent cases, I think Tunisia, with the revolution or in 2011 after Ben Ali was thrown out, I don't think they have got the assets back yet, in spite of all the tools we have. So I think the UN should look on it and improve it. And help.
Indeed, we have a UN independent expert in the panel.
Yes.
Taking your recommendations forward on asset recovery that you presented, what do you think are some of the next steps in just improving some of the challenges and obstacles to this process, in your view? How would you highlight your recommendations?
I guess me, Matty, yes?
That's right, yes.
Thank you, Eva, for the perfect segue for me to talk about something that has been concerning for a long time. And it was part of what I did present in October to the General Assembly as well, which is that there is a need for a global tax authority, but I would actually push forward and say a global fiscal authority, because while we talk about beneficial ownership and the registries, I think there is this almost elephant in the room as to who will hold the data. Who will protect the data, who will make sure the data is not being misused. And I think it makes a wonderful case for there to be a global assets registry, a beneficial ownership registry, with the information housed at the United Nations, or a body that globally will protect the information. Currently, information and a lot of the transactions that we are talking about are either within state jurisdictions, if at all, or they're in the hands of private entities. I think in terms of spaces like the Bank of International Settlements, I think of credit rating agencies, data sets housed in agencies, donor agencies sometimes. And while it is important they have them, I think that the problem is that the data is giving people an upper hand and power over the rest. So that is what I would say. That makes a perfect ending for me, for my recommendations on it. As far as the state assets guidelines that I've drafted, there are 13 guidelines, which I will share after this. It's up online already. And I'd be happy to receive feedback on it as well. Thank you, Matty.
Thank you. I maybe just make a brief question, segueing back to Gary. There's of course assets of many other kleptocrats, oligarchs in the US, and I guess the Klepto Capture Task Force, in principle, doesn't limit the mandate to the current concern about sanctioned Russian oligarchs. Could the mandate of that be enlarged to also include persons of interest to asset recovery efforts by states from other regions and other countries as well?
Well, I think that is what we are beginning to look at. So the Klepto Capture Task Force right now its mandate is limited to the Russian oligarchs.
Oh, okay.
We now realize that through coordination and communication, as I said, no new laws, no significant new resources, has significantly stepped up the priority of these requests. And so the question is, what are the learnings that we come away with after this experience to say both that the lessons should be made permanent, that is the ability to share information and identify information on a much more timely basis, and to expand it to additional countries. As you know, Russia is not the only place where there are oligarchs hiding money or bad actors hiding money in the United States. And so can we make it permanent and expand it to more countries? We would argue that the evidence would suggest yes, and we are in the process. In fact, Transparency International right now is doing a report on the repo task force, so not just the US, but all the countries involved in the repo task force, and what are the opportunities to improve information sharing permanently. Hopefully we'll have some ability to talk more about what we find by the summer. It's a lengthy process to get all the interviews and everything done. It's not just a matter of crunching data. So hopefully we'll have more to share later, but that is exactly the right question. And I think one could be transformational in terms of how we proceed on these cases going forward.
There's an audience question, if anyone wants to pick this up. Could asset recovery finance itself? I heard you recovered 10 billion worth of assets. Did that increase the budget for this activity, i.e. asset recovery itself? So yeah, it's a costly process, but could some of the proceeds of recovery be used for further asset recovery? And has that been done? Maybe it's a question to Eva, because I think asset recovery usually needs the financing of the state where the assets are located to investigate. So it hinges on that. But then I've seen that in some cases, those assets, those costs of pursuing recovered assets are deducted from what's actually given back. Yeah.
The question was, could proceeds of asset recovery be used to recover assets?
Yeah.
I think that would be very dangerous because the legal fees are tremendous, especially in the UK, for instance. So there would be not much left to return. The most successful recovery is probably when the state who wants the money back has very competent and aggressive lawyers that are successful in getting through all the obstacles. But still, I think there are so many fundamental problems. There are no quick fix to get it easily done, because you need to be able to prove that you are the real owner of this money that is in the UK bank, and it looks like it belongs to Mr. So-and-so, and you have to show as the state that you are the really owner of this money. And this is a very complicated process, legal process, costly. I think there is one thing we could do that would limit the resistance of the looters. It is that they should not be allowed to finance the legal fees they expose to resist on the contested assets. You see, I remember in the Abasha case, when they were fighting against Nigeria, all this time, he had access to the funds and his widow, and they paid for years the legal fees on the disputed amount. And maybe that we could regulate, and maybe we could forbid that, and that would deprive them of the means they have to appeal every decision also, because every decision is going through the whole system. So it is also because this is how the justice works. You have the right to appeal, and they are abusing this right. So that could be a vulnerable point.
Thank you. That's really helpful. Gary, go ahead.
Well, just completely agree, especially as I look at the US, there's no justification to say that stolen assets should be taken by either the police or the prosecutors. We have taxes that pay for our police and prosecutors, and I don't think that using money that belongs to other and often more vulnerable populations should be used for U.S. Law enforcement. That said, there are some laws here in the United States that allow for some reimbursement or payments to whistleblowers and to incentivize whistleblowers. And I think that those laws have helped to identify and find assets that we otherwise would never even know about. So I suppose I would argue that some of the whistleblower funds and programs have been effective in helping us to uncover previously unknown assets.
Thank you. I mean, whistleblower protection is an area that could really help find more stolen assets. And the legislation here varies a lot from country to country. I understand France has one of the best legislations for whistleblower protection. Eva, would you comment on the French, or how would you say it works currently?
You know, that was the Sapin 2 laws from 2016. That was a huge progress. But since then, the EU has put forward in 2018 a directive on whistleblower protection that is very strong. And this is now implemented, or should be, in all the member states, meaning that you can do no more retaliation, you can't fire the whistleblower. The whistleblower has the right to go directly to the authorities, to the police. He don't need to go any longer by his superior, because in the Sapin 2 rules, in order to be protected, he had to play by the rules and prevent his superior first. And then it was the end of the story most of the time, because that was the first person concerned. So this EU directive, that was also the Greens in the European Parliament, we brought that through, we made that happen. That we were at the origin of this directive, and the Commission didn't want it first, and we fought a lot along with others for sure. And this is now a reality that in the European Union we have a very strong whistleblower protection. They can go to the police, or they can go to the press even, and still have the protection foreseen. The weakness is still that there is no money there for them to pay for their lawyer when they are in lawsuits, for instance, and for the difficulties they encounter. So I also see that from my practice as a lawyer. It is very difficult to be a whistleblower, even with good laws, because you are taking a personal risk, and because it's not easy, for instance, to find a new job if you cannot stay in your job anymore. And that's the case most of the time. So, but still, I think we have good laws. They can still be improved, and we should have an institution with the possibility of taking their legal fees on board, so they shouldn't be ruined by the legal fees.
Thank you. Anyone else like to comment on just whistleblowers before we go to closing remarks? Okay, well then we go to closing remarks. This has been an excellent panel to discuss some of the changes that we've seen since the start of the war in Ukraine, in some of the motivations on seeking sanctioned Russian oligarch assets, and indeed assets of all oligarchs and all persons who've broken the law anywhere in the world. Would anyone like to do some closing remarks? I will go from my left in my panel. Atia, any closing remarks you'd like to make?
Yeah, well, I think what I would like to reiterate is that to date, a lot of the conversations around this topic have not touched on the issue of human rights. And I think that using the lens of human rights can be extremely useful going forward, not just in the particular case we have now where there's political will, but in the future. It allows for a more equal level playing field in trying to return assets and even stop assets from being moved in the first place. Thank you.
Thank you, Tia. I'll go to Gary for closing remarks.
Sure. And again, thank you for having me. This has been a really interesting discussion, so glad to be a part of it. I guess the only thing I would want at the end, and I often do this at the end of these types of discussions, is to say that, you know, people have been working on these issues in transparency for many, many years. And I've heard from some corners that, you know, we didn't make the kind of progress we were hoping, and there's still a lot of assets that are moving around the world secretly, and et cetera, et cetera. And so maybe it's time we move on and try and think of a different strategy. And I guess I would say that seems odd to me, because all the work that everyone on this panel and people all around the world have worked on to improve transparency, and the coalition and all your members, it's finally starting to pay off. We're finally starting to see the, you know, global North countries begin to take some responsibility. Transparency International has been publishing, along with its Corruption Perceptions Index, its Trouble at the Top series, talking about the complicity of the so-called clean countries for years. And it's only, if I feel, in the last few years where there's been some recognition, and you're seeing some anti-money laundering directives at the EU that have gone through, and the US starting to take some responsibility in moving its laws. Look, it's not perfect, and we have a lot of fighting to do. So I don't want to overstate it, but I do feel like people should, at this point, be joining the fight, not stepping away, because I think there is an opportunity to finally make some progress on issues that are undermining, as people have said, you know, the human rights and economic justice around the world. So that would be my my encouragement to anyone listening.
Thanks. And indeed, we have some of the veterans of this struggle here on our panel who've been at it for more than 20 years, including Eva. What would you like to say in terms of closing remarks?
Well, I like to hear that Gary is optimistic, because my experience is rather that it is more and more, I mean, the fact of using tax havens, hiding, is growing. I looked at the figures in Norway, for instance, that used to be a social democratic country with a very strong state, with a protection of its citizens. The increase in the use of tax havens have been some 70%. And we were in the forefront against the tax havens. We had a task force along with France, I think maybe not 10 years ago. And you know what? In 2020, the central governor of the Norwegian bank went out saying that tax havens had many advantages. You thought maybe they had very good rules. And that was because they wanted to recruit the head of the Norwegian sovereign fund, who was a hedge manager, and he had made his fortune from tax havens, from Cayman Islands, and all of a sudden in Norway, that was totally okay. So you see, there are huge setbacks, I think. And I would like to think that this oligarchy case, where we see so clearly that we are powerless, you know, I mean, when you're not able to tell who are the owner of your infrastructure, of your ports, of your, when you don't know who they are, like in Norway today, because we wanted to be part of the big financial game, so we wanted to be competitive, I guess. I think this is a security risk even. And so I am rather pessimistic. I think that the vision to stay away from taxes and and to hide away is really very strong. And I see that in Europe, we are still delivering these golden passports that I think we managed to forbid it, but they are still there. So when we try to block the Russian oligarchs' assets, they also have a passport from Malta or from elsewhere, and they can have the assets under that name. So, you know, there are not that many of us fighting for a better world, and very, very many people who are fixing and who don't want to participate in the common world. They believe that they are not part of it. But reality, I think, and especially now, maybe will help us. But there is still a lot of work to do.
Thank you, Eva. With those remarks, I'd like to close this event and thank our audience for participating, for asking the questions, for staying with us for the whole time. And thank you on behalf of the Financial Transparency Coalition and ICRICT to everyone who participated. Thank you and goodbye. Thanks.